Hello, everybody. My name is Ross Lemke. I'm the director of the Privacy Technical Assistance Center. Today, we're going to be diving into everybody's favorite topic, FERPA. What? No? Just me? Well, trust me, it's going to be fun, or it'll at least be informative. Today, we're going to be exploring data sharing responsibly and effectively within the framework of FERPA. Here's the disclaimer, also known as the legalese slide. This session provides practical tips, not official Department of Education policy or guidance. So for official guidance, you do know where to find us online. So what are the most common questions I get around student privacy? I have kind of a top three. Will this webinar be recorded? Clearly it is, because you're watching it on our YouTube channel now. Are you going to send out the slides? Yes, we will be sending out the slides. In fact, if you registered for the webinar, you should have already received the slides. If you would like a copy of a PDF of the slides, send us an email to privacyta@ed.gov. And finally, why didn't you answer my question? Well, there are a lot of people on this webinar, and we just do not have the time to address every single question. So all questions that you may have, please go and submit them to privacyta@ed.gov. Data sharing is complicated. It is never black and white. Think of it as 50 shades of FERPA. So every data sharing request has its own set of unique risks, rewards, and considerations. So each one, you're going to sit there and have to go and evaluate them. Obviously, you have to evaluate as to whether or not it is permissible under state, federal, local laws. And throughout the process, if something seems off, you have questions about it, ask questions, pause, ask, document, reach out to help. Call us at the Privacy Technical Assistance Center or your own local legal counsel. So, the classic dilemma. You have data. Somebody wants it. But just how much and why? So, again, your agency has a ton of data that's, used appropriately can find out a lot of fantastic and interesting things. So when you get third-party requests to use that data, they tend to ask for a lot of it. In fact, sometimes they ask for all of it. So researchers love data almost as much as I love coffee, maybe more. But let's pause and remember something critical here. So we are not dealing with databases full of ones and zeros. We are handling sensitive information about real children. So if this data were to be used inappropriately, released, breached, used irresponsibly, it could genuinely hurt a kid. And I don't know about you, but hurting kids isn't why I got into this business. So this is why clear agreements, transparency, and ethical uses of data are so crucial. So privacy. Privacy matters because trust matters. If parents don't know what's happening with their child's data, they may just assume that it's going to go straight to the dark web. So transparency reduces fear and builds trust. If you are ever unsure about sharing data, I think a fair question to ask yourself is, if this were my kid's information, how would I want it handled? Framing it personally can help make privacy decisions clearer. Now, I personally come from a data background. I think data is great. I think data is awesome, but not everybody feels that way. Student data is incredibly powerful when used responsibly. You can use it to improve education outcomes, policies, and the overall student experience. But remember, with great data comes great responsibility. Protect it and respect it. And again, always prioritize transparency too. It's not just a good practice, it's your strongest tool for building trust. Clearly communicates why a particular data sharing project benefits students, schools, communities. And if you can't clearly articulate that value, it's a fair question to ask that perhaps you need to revisit the research question. So when a request for data comes in, I think personally, in my opinion, the first question that an agency should ask is that, can you take aggregate level data versus individual level data? So aggregate data is like giving somebody a group photo. Nobody in particular really stands out. Now, of course, individual level data, however, is much more like a close-up portrait, powerful, detailed, yet that also demands stronger protections. Now, properly aggregated data can typically be disclosed without consent. Of course, that is easier said than done. For example, example reporting that 500 kids scored advanced on your state math assessment isn't particularly revealing. But, if I say that 100% of third graders named Cuddle Pumpkin got sent to the principal's office 5 times last month, that's incredibly revealing. Now, to be clear here, Cuddle Pumpkin is not actually a real student somewhere. He actually happens to be my occasionally naughty puppy with a very unfortunate nickname. But you get the general idea. Small cell sizes can unintentionally identify individuals. Always think carefully about how data is aggregated before you share. For more information on this, I'd also encourage you to go to studentprivacy.ed.gov and view our resources on disclosure avoidance. So under FERPA, the default way to make a disclosure to a third party is consent. Consent is gold standard. Getting it at scale, though, that's sort of like herding cats. So in general, that is why most researchers or third parties look for an appropriate FERPA exception when they're getting ready to do a data sharing project. So just like with your exceptions, though, with consent, it's good to document clearly who, why, what, when. But the general rule under FERPA, under consent, is that consent has to be signed, dated, and must specify the records that may be disclosed, the purpose of the disclosure, and the identifying the party or class of parties to whom the disclosure may be made. Now, of course, like I said, getting consent from everybody is very difficult. So we have exceptions. So FERPA has a number of statutory exceptions to the consent rule. FERPA exceptions are permissive, not mandatory. So what I mean there is that if you meet the criteria for the particular exception, you as an agency, the holder of the data, is permitted to make a disclosure. You don't have to. So just because the cookie jar is open doesn't mean you should eat all the cookies. So use good judgment and always check on your state and local laws too. Now, sometimes I'll hear from in the field, well, this data sharing request is fine. We have a data sharing agreement. Well, that's great. That's interesting. You know what? I don't care about your data share agreement. Well, I don't care about your data sharing agreement yet. So the key question here isn't whether or not you have a signed agreement. It's whether you actually have an applicable FERPA exception to consent that justifies or permits sharing the data. So the exception is the starting point. The agreement is what comes afterwards, after you've established that the exception applies. You have to get the order right. First, find your FERPA exception, then document it clearly in your agreement. Again, I love agreements, but like I said, agreements come way downstream. So when you're thinking big data sharing efforts, of all of the myriad of FERPA exceptions, there's several that kind of come into play when you're talking about data sharing. First of these would be the audit valuation exception, studies exception, directory information, and finally, school official exception. So if you want to get any more specific information, we do have a handy little one-pager called the FERPA Exception Summary that is, you guessed it, available on studentprivacy.ed.gov. That kind of goes into depth on these specific exceptions, how they can be used, and what some of the other requirements are. And this here is a nice little screenshot of the aforementioned resource. In fact, you could just not even skip listening to this entire recording and just go ahead and download this. Actually, I prefer you listen to this recording because we're going to cover some really interesting and helpful material. Well, hey, we're just gonna, and I hear this all the time, and sometimes, I make light of this, but we will hear, well, we're just going to use the research exception. So it's kind of a running joke here on PTAC that if I personally hear the term research exception, I get a little annoyed. Maybe I get a lot of annoyed. So why is that? Am I just being too sensitive? Well, here's the thing. So FERPA does not have a statutory exception called the research exception. FERPA has something that's called the studies exception. So the studies exception states that prior consent is not required if the disclosure of the PIIs from education records is to organizations conducting studies for or on behalf of educational agencies or institutions to do one of three things: develop, validate, or administer predictive tests, administer student aid programs, or to improve instruction. So why does hearing the term research, exception set me off? Personally, the reason that it sets me off a little bit is if you don't know the name of the exception that permits you to get data for your particular project, as a privacy professional, I get worried about what else you may not know about FERPA and your responsibilities to safeguard the data. So it's completely fair to ask the researchers that are using your data, again, legitimately using your data, to take training that make sure that they can be the best stewards of the data that they are using on your behalf. Now, one of the interesting things about the studies exception is that when under the studies exception, under this particular exception, a written agreement is required. It specifies that you must have a written agreement. Now, there are some FERPA exceptions that don't require a written agreement. Now, personally, I feel that written agreements are your best friend. So, good agreement that clearly specifies purpose, data involved, usage limitations, no identification outside the study team, and most importantly, when to hit deletes. So to be painfully specific here, think of it sort of like ordering a pizza. Be exact about what toppings you need. So if you're vague, you might get anchovies, and nobody wants anchovies. So I think another best practice recommendation here is to be very specific, to cite FERPA's studies exception and to provide the justification for why you're using the studies exception. Again, this is a best practice, but in my perspective, if you cannot articulate a justification on how you can use the studies exception for this particular data sharing effort, I am going to question whether or not the studies exception is the most appropriate or even applicable for this particular data sharing question. So the studies exception, the agreement shall specify the data that's going to be disclosed for the purposes of the study. So we think that's providing a specific list to be disclosed. You can either put in the body of the written agreement, or you could include it as an appendix. I think it's helpful to go and state or reaffirm the ownership of the data. Spoiler alert, it is your data. Agreement shall state that PII from education records will only be used for the purposes of the study. So put provisions in the written agreements that around limitations of the use of PII. Yes, it might stay those requirements like actually in the law that you may have to reference a website or the Federal Register to get to, or they can be there and you document it in your written agreement. Include a clause that, again, that will not allow parties to disclose the data for other purposes. The agreement shall state that the organization will conduct the study in a manner that will not allow personal identification of parents in studies by anyone other than representatives of the organization conducting the study. So say you're writing a report that is putting out aggregate data. Some best practices here to meet this requirement would be to determine a minimum cell size requirement. Many K-12 state education agencies have set their own minimum N size for their own reporting. No reason that you can't codify those same rules in your agreements with researchers and asking them to use those same cell size requirements. You could also put in stipulations that would require review of the final report before it's published. If you have an internal disclosure review board, you can go put it through that disclosure review board. And again, using the powers of math, ensure that some of these aggregate data tables don't accidentally release information that is identifiable to the specific student. The agreement shall state that the data will be destroyed when no longer needed. So this is an important provision in the studies exception. So under the studies exception, there is an end date. At some point, the study is going to be over, and that third party is not going to need the data anymore. So the exception itself requires that the agreement's going to state that this data is going to be destroyed. So some best practices here would be to perhaps set some specific terms, methodology for data destruction, or maybe an appendix or a document that is like an attestation that at the conclusion, once that study is done, a representative of that third party will go and sign and affirm that that data was deleted. You may want to consider, auditing this from time to time, just to, again, make sure that the data indeed was deleted like you requested. And finally, FERPA requires educational agencies and institutions to record all disclosures of PII from education records to organizations made under this exception. So let's go look at some fancy graphics here. So a good agreement has an easy to follow structure. Again, these are best practices here, but let's go through a flow chart here. Section 1, purpose and scope. So here is where we're covering the FERPA citations, justification, and again, remember, one of 3 things. And again, if this data sharing thing doesn't fall under one of these 3 things, then the question really is, can we use the studies exception for this project? Because not all data sharing will clearly fit under an exception. So again, develop, administer predictive tests, administration of student aid, or to improve instruction. Section 2, inventorying the data that is going to be disclosed. Again, this could be in an exhibit or appendix. So section 3, restrictions on data use, limitations on redisclosure. Section 4, how that study is going to be conducted. So you can specify access controls. You can ask them to have some sort of data security plan, or reference to their own data breach incident response, as well as notification requirements in case something were to go sideways and need to involve your incident response teams. And then section 5, data destruction. So that carries us through the audit evaluation exception. We still have, the studies exception. Now let's discuss audit or evaluation exception. So the audit or evaluation exception is an exception under FERPA that states that prior consent is not required if the disclosure of PII from education records is to authorized representatives of the FERPA permitted entity to audit or evaluate federal or state supported education program, or to enforce or comply with the legal requirements related to those programs. So under this exception, if you are providing data to a third party that isn't one of those FERPA permitted entities, such as, say, your state's Department of Education, then a written agreement will need to be put into place that is going to designate that third party as the authorized representative of the FERPA permitted entity. So that written agreement shares some commonalities with a studies written agreement. So, it's going to designate an authorized representative, that FERPA permitted entity. It's going to, again, sound familiar, specify what PII is going to be disclosed for what purpose. In this case, it's going to describe the activity that makes it clear that this is an appropriate disclosure under the audit evaluation exception, and a requirement for that authorized representative to destroy the PII from education records upon completion of the audit or evaluation, and specify the time period in which the information should be destroyed. So the permitted entities under FERPA are Comptroller General of the United States, the United States Attorney General, U.S. Secretary of Education, states, and local education authorities. So an authorized representative is defined as any entity or individual designated by a state or local education authority, or an agency headed by, again, reference to the statute, to conduct the audit or evaluation, or any kind of compliance activity in regards to the legal requirements related to those programs. So again, this is where we get to the written agreements. A lot of it looks familiar, doesn't it? So Use the PII only for the authorized purpose. Protect the PII from further unauthorized disclosures. Destroys the PII when no longer needed for the authorized purpose and in accordance with any specified time period set forth in a written agreement. So some best practices. Again, requirement is to specify the data that may be disclosed. Just like with studies, we think it's a good idea to provide a specific list of the data, included in the body of the document, or again, like before, as an exhibit or an appendix, and stating and reaffirming the ownership of the data. Now, with audit evaluation, one of the requirements is you need to describe the activity in such a way that makes it clear that it falls within this particular exception. So be specific. The more detailed, the better. So cites FERPA's audit evaluation exception and provide the justification for using that exception. And just like before with the studies exception, if you cannot articulate how this particular project fits this exception, then I think it's fair to sort of revisit the requirements. And then just like with the studies exception, there is a requirement to do recordation. FERPA requires educational agencies and institutions to record all disclosures of PI from education records made under the audit or evaluation exception. Some best practices. Specify points of contact and data custodians. Now, position titles are fine. The key here is, if there's questions about the effort or there's something that's gone wrong, and you're looking at the contract, it's good to have an idea of who you can reach out to, especially if you have to reach out to them quickly. You can have multiple points of contact. So if your main point of contact is on vacation, you don't have to wait till they come back from the beach. You can go down the list and talk to their backup. Some additional best practice recommendations. Access control. So who's going to have access to the data? And then data security provisions. So again, it's your data. You can be as specific as you like about how that data is protected. A data breach response plan. They should have one. You should have one. It's great to think that your data is never going to get breached, but we see what happens every day in the news, and there are breaches that happen. So it's a pretty good idea to have a plan in place in case the worst happens. And then finally, it might be helpful to put stipulations there that would permit you to sort of review and approve the reported results. Again, with some of these provisions in the written agreement, there's obviously the required parts of it, but some of these additional provisions or best practice recommendations, it's just like getting a contract for anything else. It's signed by both parties. If there is a provision that isn't acceptable to one party or to the other, then people don't have to sign the contract. Now, there are some things, the mandatory elements under this exemption, that are non-negotiable, but you can always put more in there, especially if the provisions that you are putting in there, say, address some specific state laws that you need to abide by, or if it's just some additional protections that make your agency more comfortable in engaging in the data sharing effort. Some additional best practice recommendations. So again, remember, contracts, legally binding. So you can consider maintaining the right to audits, terms for conflict resolution. Again, we all hope that Nothing bad is going to happen. The project starts, the project ends, everybody's happy with the results, but you can put provisions in there to handle conflict resolution. So I've covered two large exceptions. Well, one of the exceptions that a lot of our attendees tend to be the most familiar with is an exception called the school official exception. So, important thing to understand about the school official exception is the name. It is a school official exception. So typically that exception is going to apply to colleges, your local education agencies, and schools. You're not seeing that exception primarily in use at the states because they're not schools. Now, schools, under this exception, can disclose PII from education records without consent if the disclosure is to other school officials within the school, including teachers, whom the school has determined to have legitimate educational interest. So who is a school official? Well, you're going to find out who that school official is because it's designated in your own institution's annual notice of FERPA rights. Which leads us to that next bullet point of that states that schools can outsource core institutional services or functions that involve the disclosure of education records to third parties such as contractors, consultants, even volunteers, provided certain conditions are met. These conditions, well, first, determine who is a school official. In your annual notice, you're going to establish the criteria about who is a school official and what constitutes a legitimate educational interest. In general, we tend to see that a legitimate educational interest is defined as needing to know something to do your job or function. So in that annual notice, typically you'll expect to find categories. Maybe it's teachers, principals, administrative staff, contractors. It's going to vary from school district to school district. But if you have an employee that doesn't fit one of those staff categories, then I think the question would apply about whether or not they count as a school official. It's always a best practice to go revisit your annual notice of FERPA rights on a regular basis to make sure that all the people that in your school or district that are legitimately touching and using data and using it appropriately are properly included in the categories that you have in your annual notice. And then finally, the agency or school, district, college uses reasonable methods to ensure that school officials only obtain access to those education records in which they have legitimate educational interest. Now, understand that, again, schools don't have unlimited resources. So under this exception, there are provisions that permit a school, district, college to outsource institutional services or functions to a third party, outside parties. And in these cases, those third parties can be considered to be quote unquote school officials if that third party performs an institutional service or function for which that school would otherwise use their own employees. Has to be under the direct control of the school with respect to the use and maintenance of those records, and complies with the FERPA requirements regarding PI from education records and any redisclosure requirements. So when you look to your annual notice, one of the things you would want to look to if you're considering outsourcing, certain functions to a third-party school official is to whether or not that third party would fit the definition of a school official as is in your annual notice. So notice the title of the slide here says, well, why not the school official exception? So again, the Depending on what that third-party researcher is working on, say they are doing a national study on X, Y, or Z, and you are a small district in a rural part of the country, it begs the question about whether or not this would be something that your small school district or college would otherwise use their own employees for. And again, we're talking for a national study. So I think that's a harder business case to make, which is why it is not as common to see the school official exception used, again, with third parties conducting research. Typically, the studies or audit evaluation exception would be looked to first. That is not to say that this exception can't be used in all cases. What I would say is the use cases or the possible use cases would probably be much more narrow, and it would probably be a good idea to seek outside assistance, talk to your legal counsel, reach out to PTAC. We'd be happy to jump on a call with you to discuss. Well, what about directory information? So again, if you've been in the FERPA world for a while, education world, directory information is an easier way of disclosing data. So defined in the statute, directory information is information in a student's education records that would not generally be considered harmful or invasion of privacy if it were to be disclosed. Now, this could include names, address, phone number, grades, photographs, but each district, college, university is going to determine their own directory information policy. That also includes an opt-out provision, which means that, as part of the directory information exception, when a notification is made to parents of students or students in the school community, beginning of the year, what is considered to be directory information at this particular institution, and the process for, well, one, the parents or students' right to opt out and the process for doing so. What that means is that if somebody were to opt out of directory information, then their information could not be released under this exception. A newer aspect of the FERPA, specifically the directory information, is something called the limited directory information policy that further restricts who can receive directory data. So, what typically the classic way of doing it was listing what elements you considered to be directory information. The limited directory information policy also, you can put provisions that specify the parties that are permitted to receive directory information. So if that third party is not on that list, then they cannot get data under this exception, well, without getting consent. So one more point on directory information before we continue, and that is, if you're doing anything at scale and you're trying to use directory information, it becomes problematic. Because of the opt-out provisions under FERPA, if you're doing a data request that spans multiple agencies, you're not going to get a complete data set because there are going to be a subset of students that have been opted out of directory information. But also note that agencies are permitted to have different directory information policies. So again, that's in their directory information notice. So what's considered to be directory information at one institution may not be directory information at another institution, which makes, again, doing the research at scale using this exception highly problematic. Now, I think the thing to understand, as we start to wrap up here, is that there are some projects that might not clearly fit an FERPA exception. So I presented this sort of slide earlier, and this is the general, what is needed for consent slide. And what I've said earlier is that, again, education data can be a very powerful thing, but it has to be done appropriately. And we always look to the FERPA exception that permits the disclosure. There are some cases, however, that don't fit an exception. And that becomes problematic because it could be a great, fantastic idea, but an exception doesn't apply, which means the disclosure would require consent. Again, for example, say you want to go and share data with a third party, student level data, for the express purposes of providing every student in the States a free puppy. Now, don't get me wrong, I love puppies, but there isn't a free puppy exception under FERPA. Now, again, don't email us and say, well, actually, dogs might be able to, help education outcome, something like this. And again, as the dad who has to take the puppy out at 5 o'clock in the morning, puppies are a lot of work, but I digress. In those cases where, again, you want to do the thing, you want to do the research, but you can't find the appropriate exception, then you can still do it. You just need consent. And consent doesn't have to be a bad thing. In fact, I think it can be a very good thing, because when you're getting active consent, people are deciding to engage in the project, and this allows them to make an informed decision about whether or not they see the value in what is being done. And we've seen multiple examples of this where, maybe it's a third party that's not a school official that needs information for program evaluation for particular students that are in this program. And again, no appropriate exception, but you can build consent in at the beginning of the process, where if you want to get services under this, you just consent to the disclosure. And again, this is an area where transparency helps. Explaining clearly what the data is going to be used for, what's going to be disclosed, and who's going to get it. It can be more work, but it can also be a really positive thing as well. So let's talk about sharing data versus collecting data. So FERPA covers information that is maintained by a school or an educational agency. Some research projects involve collection of additional data elements. Depending on how that new data is collected, there is a whole nother law that might apply. And that law is the Protection of Pupil Rights Amendment, PPRA. So this law was amended in 2001 with the No Child Left Behind Act. It is primarily known for its provisions dealing with surveys in K-12. Now, there's this particular law, and this is not a PPRA presentation. If you need more detailed information on PPRA, again, direct you to studentprivacy.ed.gov. But PPRA does, primarily has provisions for allowing parents to inspect curriculum, to have limitations on the using personal information collected for students for marketing purposes, and some provisions around non-state mandated invasive health procedures. But it's really, for the most part, it's primarily known for its provisions dealing with surveys in K-12. So a lot of these resources here will give you a really good understanding of PPRA. But if you are collecting information and by administering a survey to a student at the K-12 level, because PPRA is a K-12 law, and that survey has questions that I would say cover topics that you may be uncomfortable talking about at Thanksgiving dinner, there is a fair chance that PPRA may be implicated. So I think it's a good idea to review the guidance that's on the Department of Education's website and to reach out for assistance to see whether or not PPRA applies. And again, there are a number of other rules that apply for school districts as well. So I'm going to leave you with some tips. Understand, if you're an education agency, understand that the laws that apply to the data that you are maintaining. So again, like FERPA, but of course you may also have other states, local laws that apply to the information as well. And just speaking to FERPA here, that if the criteria for a FERPA exception is met, then disclosure is permitted. You're not compelled to make the disclosure. Again, you may live in a state that has additional laws that apply, but you are ultimately responsible for the student data no matter where it lives. And again, like I think student data is great. You can do lots of fantastic things with it. There are rules that you have to follow that protect the privacy of the children that is in the data that you are using. And those rules, obviously there's the legal requirement that they must be followed, but if some of this data were to get out, there could be actual repercussions for the kids, and nobody wants that. You, as an agency, are ultimately responsible for the student data no matter where it lives. But again, this is not all doom and gloom. There are resources out there. Contact PTAC. We can help you. We commonly will sit there and work with researchers, work with agencies to figure out the appropriate way to legitimately share data. Now, if you're a researcher, my advice to you is to only request the data that you really need. So if you receive data legitimately under an exception, you have to protect the data that you hold. Your future ability to conduct educational research may depend on you being a good steward of the data that you have. And PTAC is a resource that you can go to for help. So we have a lot of resources on data sharing here. You'll be able to find these on our website, studentprivacy.ed.gov. Here's our contact information. If you have a question about any of this, please, please, please just reach out to us. We are happy to help, and oftentimes we are just a phone call away. Thank you so much for your time, and we'll see you at our next webinar.